I'm Ben Meiselas from the MeidasTouch Network. The United States Supreme Court has just released its findings and conclusions relating to its so-called investigation regarding who leaked the Dobbs v. Jackson Women's Health Organization decision, which overturned Roe v. Wade. The decision was leaked on May 2nd of 2022 before the decision was ultimately issued by the Supreme Court more than a month later on June 24th of 2022, when this so-called investigation by the Supreme Court looks like a complete cover-up by the Supreme Court. As we've talked about here on the MeidasTouch Network and have others discussed, it seems like the leakers are probably some of these right-wingers who had everything to gain by leaking it so that the actual opinion while it was being drafted would not change once it became accessible to the public back in May. We also know that Justice Alito has a history of leaking Supreme Court opinions. There was a former right-wing evangelical who has now since exposed a lot of the corruption that existed by the right-wing MAGA extremist on the court with evangelical right-wing leaders. And he said that Alito would give decisions to his friends at dinner parties. Alito denied that, but there's a lot of email substantiation to that. So let me pull up right now for you this investigation that took place, and let's highlight some of the key points. And I want to flag this right away. The Supreme Court, as part of this investigation, as far as we know and what's written in the report, there was actually no communication with the Supreme Court at all. The people who seemed to have been investigated were the law clerks and staff, but that the justices themselves were not even questioned. I mean, how in the world could that be viewed as a valid investigation? And if you want to know who's the one in charge of setting those parameters, it's Justice John Roberts, the Chief Justice of the United States Supreme Court, who is a right-winger, perhaps a slightly more moderating force than some of these other right-winger Trumper MAGAs on the Supreme Court, but nonetheless a right-winger. And it looks like they were just trying to protect themselves. So let's pull open the first page that talks about the report. The report was ultimately prepared by the Marshal's office, but the Marshal of the Supreme Court conducted the investigation. But here is what the first page, the statement of the court, they then attached the Marshal's investigative report. But this is what it says. It says, in May 2022, this court suffered one of the worst breaches of trust in its history. The leak of a draft opinion. The leak was no mere misguided attempt at protest. It was a grave assault on the judicial process. To meet our obligations as judges, we accept submissions from parties in amici, we engage advocates at oral argument, and we publish explanations of our final decisions. All of this we do in the open. Along the way, though, it is essential that we deliberate with one another candidly and in confidence. That phase of the judicial process affords us an opportunity to hone initial thoughts, reconsider views, persuade one another, and work collaboratively to strengthen our collective judgment. It is no exaggeration to say that the integrity of the judicial proceedings depends on the inviolability of internal deliberations. For these reasons and others, the court immediately and unanimously agreed that the extraordinary betrayal of trust that took place last May warranted a thorough investigation. The Chief Justice assigned the task to the Marshal of the Supreme Court and her staff. After months of diligent analysis of forensic evidence and interviews of almost 100 employees, the Marshal's team determined that no further investigations was warranted with respect to many of the, quote, 82 employees who had access to electronic or hard copies of the draft opinions. In following up on all available leads, however, the Marshal's team performed additional forensic analysis and conducted multiple follow-up interviews of certain employees. But the team has to date been unable to identify a person responsible by a preponderance of the evidence. A public version of the Marshal's report is attached. I'm going to talk to you about this Marshal's report in a second, where you see from the intro that I just read, though, it doesn't appear that they're saying the actual justices themselves were interviewed, or that the justices' phones were forensically examined, or the justices' emails were forensically examined. Here's what it goes on to say. Recently, this court consulted with Michael Chertoff. Mr. Chertoff is a former Secretary of Homeland Security judge of the U.S. Court of Appeals for the Third Circuit, an Assistant Attorney General for the Criminal Division of the U.S. Department of Justice, and a U.S. Attorney for the District of New Jersey. He literally was the former Secretary of Homeland Security, who they had look at this. And they said Chertoff told them, oh, look, it was all good. The investigation was done diligently and professionally. And then the Supreme Court goes on to say, the Marshal reports that investigators continue to review and process some electronic data that has been collected, and a few other inquiries remain pending. But let's actually go into this, for example. So when you go to Section 1, Conduct of the Investigation, let's pull this up right here. It says, the investigation focused on court personnel, temporary law clerks, and permanent employees who had or may have had access to the draft opinion during the period from the initial circulation until the publication by Politico. It was ultimately leaked to Politico. But it doesn't appear that they're mentioning these Supreme Court justices themselves there. This is what it also talks about. It says the investigators reviewed the call and text logs retrieved, but found nothing that was relevant in the limited logs. We'll go on a little bit later. It says the purpose was to determine whether an employee might have researched the legality of disclosing confidential case-related information, possibly indicating the person's intention to do so or concern about having done so after the fact. So what they did in this investigation was they forensically examined the staff, the employees, both the permanent and part-time employees, their Google searches at the office, to determine if they were Googling things like how to get away with leaking. Come on, you think that that's what they're actually going to Google? And again, it doesn't appear that the justices' computers, phones, and other devices were searched or that they were properly examined here as well. They go on to talk about some of the conspiracy theories about which law clerks' posts or which law clerks were named in various social media posts as being potential leakers. And here they found no evidence that these individuals did indeed leak anything. One of the things that it basically said, it says, each employee was then asked to swear to the truth of the statements in an affidavit before a notary public. Each of these employees signed a sworn affidavit. A few of those interviewed admitted to telling their spouses about the draft opinion or vote count, so they annotated their affidavits to that effect. If investigators later determined any personnel lied to the investigators, those personnel would be subject to prosecution for a false statement. So some of the people had told their wives or their husbands or their significant others about who the individual, or rather that what the draft opinion had stated. But again here, you want to go to the conclusions and findings. The conclusion and findings are basically the United States Supreme Court needs to be more secretive. And this is what they say. These are the findings of the Marshall's report. 1, too many personnel have access to certain court-sensitive documents. The current distribution mechanism results in too many people having access to highly sensitive information. 2, aside from the court's clear confidentiality policies and the federal statute outlined above, there is no universal written policy or guidance on the mechanics of handling and safeguarding draft opinions and court-sensitive documents, and practices vary widely throughout the court. A universal policy should be established, and all personnel should receive training on the requirements. 3, the court's current method of destroying court-sensitive documents has vulnerabilities and should be addressed. 4, the court's information security policies are outdated and need to be clarified and updated. The existing platform for case-related documents appears to be out of date and in need of an overhaul. And 5, there are inadequate safeguards in place to track the printing and copying of sensitive documents. The court should institute tracking mechanisms using technology that is currently available for process. So in other words, the United States Supreme Court has some of the worst security functions imaginable, some of the most outdated and rudimentary things that are guarding these very important opinion drafts that are circulating. But look, what this appears to be is a cover-up by the right-wing MAGA extremists on the court. They're the ones who had everything to gain from leaking the draft opinion. And if you go, again, remember what I said in the beginning about why these drafts and why the confidential deliberations are important. I mean, it says it here, because when these things are circulated, it allows for the justices to debate the issues, and sometimes a draft is not a final draft, and other judges can make changes within the orders. So why would it be a right-wing MAGA extremist to make it public? Well, to kind of freeze it, to stop those deliberations from happening, to stop the Supreme Court from, one of the justices from trying to convince others from making changes to the opinion. So there would be no reason why someone who supported Roe v. Wade to leak that opinion at that time, it would harm the ability to try to change it. So the likely candidate is a right-winger on the Supreme Court, and we know that there's a right-winger with a history who has engaged in leaks before, and so I don't think it is that difficult to really understand what took place here, especially when you realize that the Supreme Court did not even seem to have their justices undergo this investigation. Here's what we put on our MeidasTouch Twitter account. We said, maybe the Supreme Court can give us an Alito hint, just an Alito hint on who it was. Justice Alito. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button. We are on our way to 1 million subscribers thanks to your incredible support. It's free to subscribe, so just hit that subscribe button right now. And in addition, check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. You will love the exclusive content we have on our Patreon, and we're doing a very special thing for our Patreon subscribers. This weekend, we're having an exclusive Zoom chat with them. So join Patreon now. Be a part of that exclusive Zoom chat with me and my younger brothers who are the co-founders. Until next time, I'm Ben Meiselas from the MeidasTouch Network.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs, It Wasn't Rigged, You're Just a Loser, at store.meidastouch.com. That's store.meidastouch.com.